In this video, we're going to move on to the next major topic within the law of contract. This is arguably the most substantive topic of all of them, and this is the topic which is going to examine the creation of contracts. Now, we're going to talk very briefly in this lesson the process by which a contract is created, specifically examining the fundamental key elements that are required for a contract to exist, but we're going to also be taking an introduction to the first of these fundamental elements, which is of course agreement, and an introduction to an agreement, which we will then take into the next few lessons when we look at the component parts of an agreement and the different ways in which courts have approached whether or not an agreement exists for the ability for a contract to be legally binding. So, agreement is arguably the most foundational and the most important concept within the law of contract. And one of the reasons for this is because essentially, if we were to define a contract, we can just define a contract as essentially a legal agreement. It is an agreement between parties to do something, and that they are legally bound to do that particular thing, to perform some kind of action or to act in some kind of way. And so as a result of which, the agreement component of a contract is the most important, because it essentially establishes the foundation of what a contract even is. And so essentially, when we think about what a contract is, we have to begin with the nature of agreement. Now, as a general recap, what are the other elements of a contract that we're going to explore in this series? So we know that a contract is made up of a number of essential elements, okay? These are the four essential elements for a contract. I've written in brackets sometimes for one of them. We'll get to that in a second. So the first of these is agreement. Okay, we have to have an agreement that takes place, okay? And we'll explore what that means in a second, specifically the component parts of an agreement, the component parts being the offer and the acceptance of the offer. The next important part is this idea of an exchange of obligations, which we looked at in the previous lesson when we were examining theories of contract, because an exchange of obligations involves this idea of a quid pro quo, i.e. something for something else, which is sometimes described and is described in contract law as consideration. There has to be consideration of contract. Again, we will get to that in future lessons' time. And then the third element, which is a requirement for a contract, is this intention to create legal relations. So not only is a contract an agreement, but a contract is a legally binding agreement. It is an agreement by the parties to be legally bound to the terms of that particular contract. And so as a result of which, there has to be some kind of contractual intent on the part of the individuals in question to be entering into legal relations. There must be knowledge that they are entering into legal relations, or at least their intent to enter into legal relations is either expressly stated or is inferred from their conduct and from their actions. Finally, and this is only the case in some contracts, it is not a necessary condition for the existence of a contract generally, but it is necessary for some specific kinds of contracts. This is the idea of formality, the idea that the contract has to be structured in a particular way, and this is often described through the type of medium in which the contract is communicated. So you will find, and we will come to examples specifically within land law, for example, and the various elements relating to deeds and leases, that a contract in that particular area of law has to be written. It has to be a written contract. It has to have a certain amount of tangibility, as in it is written down on a piece of paper, for example. And so that is a requirement of formality. But that's not the case for every contract, and so therefore it is not a necessary condition for the existence of a contract in its general form. You can have oral contracts, you can have oral agreements, which can be legally binding as well. So given that these are the fundamental elements of a contract, let's begin with the first of these topics, the idea of agreement. And we're going to spend quite a lot of time looking at agreement, because agreement itself, given the fact that it is a legally binding contract, a legally binding agreement, a contract is, we have to have an agreement for a contract to be valid. And given that agreement itself is divided into two major elements, we have to spend a lot of time looking at both of them in turn. So an agreement is a two-sided obligation, essentially. It is an obligation on the part of the person who wants to make the contract to make an offer to the other parties, and for those other parties to accept that offer. It is with these two elements that we have agreement within contract law. So there has to be an offer, and there has to be the acceptance of that offer, okay? Now we will get to what negotiations leads to, and things like counter offers, and how an offer is made, what an offer actually is, how an acceptance of an offer is made, things like the postal rule, for example. We'll get to all that in future lessons time. But essentially, when we talk about the fundamental requirements for an agreement, we have to have an offer, and we have to have an acceptance of that offer. Okay, and it should also be the case that the acceptance mirrors the offer. Okay, it should be the case that there is a balance between the offer and the acceptance in terms of the ability to form the agreement in question. The final thing I want to note before we move on and look at the offer in more detail and the delineation between, for example, an offer and an invitation to treat, the kind of ways in which an offer can be made, I just want to very quickly clear up some of the terminology referring to the parties to a contract. This is very, very basic stuff anyway. Given the fact that a contract is made, or at least an agreement is made with the offer and the acceptance of an offer, the parties who form that contract, specifically the parties who form that agreement, are the offerer and the offeree. So the offerer is the person who is making the offer, and the offeree is the person who receives the offer, and presumably in order to create an agreement they will accept that offer as well. And so we'll get to this in more detail in future lessons time. Welcome back everybody to Contract Law. In this lesson what we're going to be doing is talking about the idea of contractual intent. The idea here relating to making a lot of delineations between an offer to contract, an offer to form an agreement within a contractual relationship, and delineating that concept with a number of other things that could exist, that could actually be the case. So things like an invitation to treat. This lesson is going to continuing to talk about the first major requirement within the formation of contracts, this being the idea of an agreement, and talking about the first major component of an agreement, i.e. the offer itself, the concept of the offer. Now we'll explore the requirements which are necessary to establish an offer, in addition to this idea that there has to be an intent to make an offer to contract with the other parties. So we know already that when we are looking at the first component of a contract, we remember firstly that the components of a contract include an agreement, include consideration, and they include an intention to create legal relations, and some of them include a specific formality. The concept of agreement, the first of the major conceptions of, or at least the major requirements of a contract, is split into two. The agreement can be represented as a delineation between the offer and the acceptance of an offer. Now, in identifying whether or not a contract exists between the various parties, finding a clear offer is something which is important. And when it comes to how the courts have approached this question, they have looked at a number of factors to try and make the determination on a more objective standard by which there can or cannot exist an offer in a particular factual context. So arguably the most important of this is whether there exists a certain degree of what is described as contractual intent. Was there an intent by the parties in question to enter into a contract? And so if that was the case, then the person who is making what is alleged to be the offer has to have the intent to make a contract. So often the idea of contractual intent is difficult to determine, and for the most part the importance that we have to think about is how the courts are able to distinguish between an offer, which does have legally binding implications if accepted and the other requirements for a contract are present, and an invitation to treat, which is a completely different thing, that is almost like an invitation to the potential negotiations which could give rise to a contract, and not actually having any kind of contractual binding obligations in and of themselves. So again, An offer in this context involves the offer to enter into a contract. It doesn't require, or it doesn't involve, an offer to enter into negotiations, which could give rise to a contract. A contract is legally binding, and so when we think what an offer is, it is an offer to enter into a contract. And so to find a valid offer, the court must be satisfied that there has actually been an intention on the part of everybody who is involved to enter into legal relations. So what is the approach that is issued by the courts in this regard? Well, the answer is an objective standard. The objective standard is the standard by which we try to make this determination. For the most part, the courts have believed that the identification of contractual intent should not depend specifically on the subjective intent of the parties, but rather the objective standard by which you can view the actions of the parties as being or potentially not being an offer. So it should depend on a certain objective standard to make a determination whether or not intent can be found, can be determined. And there are a number of examples and cases where this has been illustrated. The case of Storer and Manchester City Council, for example, from 1974, is essentially a case which hinges on this question about whether or not there was an offer made. Don't forget that this is an important thing to consider, because if there was an offer, and then by extension, assuming that there is the fulfillment of the other elements of a contract, there is therefore legally binding obligations, it means that the people who are involved in this particular dispute are now legally bound to perform the contract in a particular way, or suffer the consequences for breach of contract. So the question of whether or not a contract exists between the parties is one which is often tested and applied by the courts, and has been historically since the beginnings and the formations of contract law. The facts of this case are relatively simple. So we have Manchester City Council, who had made the decision to not proceed with the sale of a council property. Now, this was the case despite there being an agreement made with the claimant under an established arrangement with its predecessor. And so the claimants argued that the contract had been concluded, and then as a result of that, the Manchester City Council could not just simply refuse and renege on that decision, because there is a contract, there is a legal obligation now automatically placed to perform the contract in a particular way. And so as a result of this, they couldn't just simply change their mind and not proceed with the sale of a council flat property. They wanted to see essentially the specific performance of the contractual arrangement. Now, the question here, of course, and the dispute that is arising is whether or not, okay, there actually was a contract. The claimants are arguing that there was a contract, and so as such, the Manchester City Council would have to perform the contract, their terms within a contractual arrangement. The Manchester City Council, on the other hand, argued that no, there was not a legally binding contract, there was not an offer made, and so as a result of this, their decision to not proceed with the sale of the council property is not one that has wrapped up with it any legally binding obligations. The Court of Appeal, however, would disagree with the Manchester City Council, holding that there was indeed a contract, and they made a distinction here between an agreement and the idea of an invitation to treat. They said that in contracts, you do not look to the actual intent of the man's mind, you look at what he said and did. A contract is formed when there is, to all outward appearances, a contract. A man cannot get out of a contract by saying, I did not intend to contract, if by his words he has done so. So this is the reason why we are applying an objective standard here, because if you were to apply something of a subjective standard, then this idea of contractual intent becomes something that is a question that is applied to the specific cases of a factual matter. And so a claimant or a defendant in a case could make the argument that they did not intend to contract, and so as a result of which you may be able to get out of their contractual obligations, rather than looking at what the individual themselves actually intended. The concept of determining contractual intent is looking at the outward appearances of their actions and their words, rather than their so-called internal intent, what they actually believed. So this is the objective standard that is applied. And when we think about objective standards, one of the things that we always will hark back to within English law, whether or not we are doing the law of torts, or whether we are doing criminal law, or whether we are doing contract law, is this idea of the reasonable person standard. So in an effort to essentially ensure that there's a certain degree of consistency when applying these objective standards, the court applies what is known as a reasonable person test to an objective standard. Essentially, what the court is doing in these regards is saying, well, when we look at the actions of the parties making a contract or allegedly making a contract, the question that is asked is whether or not a reasonable person would look at the parties and their actions and their words and come to the same conclusion as to whether or not there was a contract. So if you see the words and the conversations of the people who are involved in this alleged contract, and you see the actions of them, and if you were a reasonable person, you would come to the conclusion that they were looking to form a contract, then that is the standard by which we objectively view where contractual intent arises. So, for example, in the case of First Energy and Hungarian International Banks Limited from 1993, we have a case involving a senior manager of a bank who was arranging the financial matters for the particular defendant. Now, the question here was whether or not this manager had the authority to make an agreement which was contractually binding. And ultimately, it was held that the contract was binding, owing to the fact that the manager had what is known as ostensible authority. It says here that a theme that runs through our law of contract is that the reasonable expectations of honest men must be protected. It is not a rule or principle of law, it is the objective which has been and still is the principal moulding force of our law of contract. The court must take into account surrounding circumstances which reasonable persons in the positions of the parties would have had in mind.